Good afternoon, ladies and gentlemen. I am Chief Justice Grant of the Northern Territory Supreme Court. We're at the court today for the annual Northern Territory ADR Address. This event is arranged by the Australian Disputes Centre, and I'd like to start by thanking Deborah Lockhart, the Chief Executive Officer of the Centre, for organising the presentation with her customary enthusiasm and efficiency. The presentation is being conducted a little differently this year due to the COVID-19 restrictions. Rather than being delivered to a live audience, it's being filmed for broadcast by Aboriginal Broadcasting Australia. And I'd like to thank Dr. Donna Odegaard for arranging that. Today's presentation will be dealing with the ways in which alternate dispute resolution can be implemented in Aboriginal communities. Most commentators now accept that ADR has the flexibility to allow the adoption of processes which are more suited in Aboriginal communities than the traditional Westminster legal system. There is nobody better qualified to lead that push than today's speaker, Leanne Liddle. Leanne is the Director of the Aboriginal Justice Unit here in the Northern Territory. In that role, she has been the principal architect of the Aboriginal Justice Agreement. Leanne comes from a very accomplished and well-respected family in Central Australia. I remember her when she was a star athlete as a young girl in Alice Springs. Since then, she's gone on to work in a broad range of roles involving Aboriginal justice and service delivery. Those roles have included working as a South Australian police officer in the APY lands, as manager for the APY and Maralinga lands with the South Australian Department of Premier and Cabinet, and as a senior policy officer with the Northern Land Council. She also holds office as a board member with the Menzies School of Health Research. In addition to those practical qualifications, Leanne also has degrees in law and environmental science and graduate qualifications in community development. I'm sure that you'll find what Leanne has to say today to be both interesting and informative, and a timely contribution to the debate on these issues.
Thank you, Chief Justice, for your warm welcome to the Supreme Court of the Northern Territory and for your collaboration with the Australian Disputes Centre in hosting this annual ADR Address. Hello, my name is Deborah Lockhart and I lead the Australian Disputes Centre. We're an independent not-for-profit that's here to help people resolve their disputes. Regrettably, with the COVID-19 travel restrictions, I can't be in beautiful Darwin. I'm here at the Australian Disputes Centre in Sydney on Gadigal land. I'd like to pay my respect to the Gadigal people of the Eora Nation and to the Larrakia people, the saltwater people of Darwin. I am honoured to welcome our guest speaker for the 2020 ADR Address of the Supreme Court of the Northern Territory, Ms. Leanne Liddle, a proud Arrernte woman raised in Alice Springs. Leanne has worked with and for the benefit of Aboriginal communities for many decades. From her role as a senior constable in remote South Australia to the United Nations working in Paris, Geneva and New York. By recognising Leanne's many achievements, I am inspired by her generosity of spirit and by her personal strength. I warmly welcome Ms. Leanne Liddle to present the 2020 ADR Address of the Supreme Court of the Northern Territory.
It's an honour to be invited to give the annual Alternative Dispute Resolution Address of the Supreme Court this year. And my first duty is to acknowledge the Larrakia people whose lands I'm presenting on today. I'd also like to pay my respects to past, present and emerging Aboriginal leaders across the nation. And I'd also like to take this opportunity to thank Ms. Deborah Lockhart, the Chief Executive Officer of the Australian Disputes Centre, for organising this year's event under exceptionally challenging circumstances. It's also another special occasion, as this week is National Reconciliation Week, with a fitting theme, In This Together. I certainly didn't contemplate when I was invited to do this address that I'd be sitting in an empty courtroom with no noise from the audience and no people in the seats. But what it shows is how things can change so quickly, and if we try, how we can adapt and accommodate such change. And I know it'll be a hard act to follow on from the informative and entertaining presentation given by Chief Justice Grant last year at the inaugural address, but I will try to do my best. And whilst my presentation today focuses on justice in the Northern Territory, and in particular the experiences in drafting the Northern Territory's first Aboriginal Justice Agreement, many of the observations are just as relevant and applicable to ADR across the nation. Which brings me to the crux and the title of my presentation: Is Alternative Dispute Resolution a Second-Rate System of Backyard Justice? The title has come from some of the judiciary who joked that practitioners of ADR should be charged with professional misconduct because they were taking business away from the courts and food from the mouths of lawyers. And this view was further characterised by the former Chief Justice of Australia, Robert French, who wrote in 1993, after he too had a similar experience with legal practitioners, who had stated that alternative dispute resolution practitioners operated with what was regarded by legal elites as a second-rate system of backyard justice. Perhaps this is the defensive position held by those who fail to appreciate the benefits of ADR, especially for those who are disadvantaged and less privileged, and for those whom justice is not available in their backyard. And this is why I argue that in retaining the current status quo of relying on litigation and adversarial contestation in the legal arena as the only form of redress is not only unwise, but it's also profoundly unjust. And it's unjust because we have largely failed to address the realities of Aboriginal Territorians and the justice system. We need to do things differently, but we also need to make sure that any approach that is different works to fundamentally address the asymmetric power relations, historic and those still in place today, that shape justice outcomes in the Northern Territory's backyard. So what do we know about the NT's backyard? Well, here in the Northern Territory, 30% of our population identify as Aboriginal or Torres Strait Islander. The median age of Aboriginal Territorians is 26 years, with almost 30% of this cohort aged between 0 and 14 years. 76% of Aboriginal people live in remote or very remote areas, and over half of Aboriginal Territorians speak a language other than English at home. And in our justice backyard, here in the NT, we have the highest imprisonment rate of any state or territory in Australia, with 955 prisoners per 100,000 adult population, compared to the national average of only 221 prisoners per 100,000 adult population, where almost 84% of the adult prison population and almost 100% of youth in detention is Aboriginal, where Aboriginal people make up 75% of all court proceedings and account for 88% of all breaches of bail, resulting in many Aboriginal people being refused bail only to be remanded in custody. Then, when they are eventually brought before the courts, they are released for time already served or even acquitted without charge. The most common offence committed by Aboriginal people in the NT is acts intended to cause injury, committed more often than not with a victim who is not only likely to be from the same community, but also more likely to be from the same family group. Now, you may think that I've painted a grim picture, and it sure is. And you may think that relevant parties have ignored or turned a blind eye to the possible need for alternative dispute resolution systems to occupy this space. But this is not true. In 1991, a key recommendation of the Royal Commission into Aboriginal Deaths in Custody was that imprisonment should only be used as a last resort. 7 years later, in 1997, the Northern Territory Law Reform Committee released a report titled Alternative Dispute Resolution in Aboriginal Communities. At this time, 3 arguments were made in favour of an ADR scheme. One, that alternative dispute resolution schemes may alleviate the disproportionately high levels of Aboriginal contact with the criminal justice system. 2, that the perception that denying traditional methods of belief is unjust, particularly when many Aboriginal people expressed a deep desire for some kind of formal recognition of the customary law. And 3, that communities are best placed to develop solutions given their knowledge of community dynamics, kinship systems and cultural values. The report also recognised several objections to the implementation of ADR schemes in remote Aboriginal communities, most which concerned the sacred and the secret nature of customary law, stating that it had the potential to deny the protection of women, as well as the accusation of creating 2 laws. But the committee rejected these objections, critically arguing that due to the fact such rules apply to all members of the community, regardless of their Aboriginality, it cannot be said that the creation of such schemes would breach the principle of equality before the law. In light of many more recent approaches to alternative diversion court processes, such as Aboriginal Circle or other specialised courts that operate in southern states for drug, family and domestic violence or mental health matters, the same view could be argued, given that offenders will choose to be heard in an ADR or community court process rather than the mainstream justice system. The Northern Territory Law Reform Committee report then went on to recommend that an Aboriginal Community Justice Act be legislated to formalise ADR processes in Aboriginal remote communities across the entire Northern Territory. Now remember, it was only a generation ago where arguments about customary law were poisoned by the more universal cultural wars about multiculturalism, racism, history, migration and citizenship. I would argue that given what we know now in 2020, surely we can abandon such political shadowboxing and acknowledge that any modern system of ADR will specify and limit the range of offences and available orders attached to any community decision-making structure and process. To the extent that customary law issues pertaining to any dispute or offending, so that those charged with adjudication will apply their understanding of those issues, along with the myriad of other factors, such as responsibility, harm, mitigation, and awareness of Western law. To state that the practical challenges of responding to customary law are the business of those who inherit, follow or innovate such law does not mean that appropriate ADR processes are culture blind. So we can or we should disregard cultural beliefs and values. In an important contribution by academic Kahani, he argues that generalisations about cultures are risky, given the complexities of memberships and group boundaries, not to mention the power dynamics within and between social groups. But it's important to take that risk. Attempts to avoid or transcend culture in resolving disputes pose an even greater danger of reiterating the understandings of dominant cultural groups under the guise of neutrality. Now, I agree in part, but I must reject Kahani's call for generalisation, especially given the enormous diversity between and within Aboriginal people and communities in the Northern Territory. And this diversity is partly due to what is called intersectionality. That is, the intersection between one's key Aboriginality and social situation, gender, age, location, sexuality, religion, disability or ability. Universal generalisations about Aboriginal people are not just only inaccurate, they violate our human rights and they have delivered devastating and harmful outcomes. Without doubt, we all need to be culturally informed when working with Aboriginal people, but we must not be intimidated by the cultural differences that we can or can't see existing between particular Aboriginal persons and others. Some Aboriginal academics have termed this terminology cultural courage, noting that many non-Aboriginal practitioners seek to avoid taking responsibility for relationship building and effective interventions because they respect profound cultural differences. But the responsibility for fixing the core disparity that leads to the overrepresentation of Aboriginal people in both the jails and the graveyards is everyone's, or at least everyone who gets paid a salary directly or indirectly, or whose roles impacts on or causes Aboriginal people's pain and disadvantage. Another key difference with the debate that took place in the 1990s is a recognition that ADR is not only needed in remote communities, and that's because all Aboriginal Territorians should, at least in theory, have access to ADR no matter where they reside, so long as they satisfy the eligibility criteria based on the offence or dispute and their own circumstances. One key driver behind the development of the draft Aboriginal Justice Agreement is the government's goal to reduce Aboriginal overrepresentation in prison, partly through the establishment of various diversionary mechanisms and alternatives to prison. The Justice Agreement has three aims. One, to reduce Aboriginal imprisonment and recidivism rates. Two, to engage and support Aboriginal leadership. And three, to improve justice responses and services to Aboriginal Territorians. In consulting across the Northern Territory for the draft Justice Agreement, we visited more than 140 communities over 24 months. Sometimes we visited communities twice at the community's request. And there we listened to and we heard from Aboriginal people who told us that they were so upset and angry with the ongoing high levels of disadvantage in their Aboriginal communities or towns, where people told us that over many decades they'd talked to many people, all nice, all well-meaning, many who had even left the meetings very tearful. Many had different titles and they came from different places, yet nothing much had changed in their lives, their children's lives, or their grandchildren's lives. And from what we saw and heard, and from the evidence and data that we collected and analysed, there is no doubt in my mind that as Aboriginal people, we've been in a backyard marinating for far too long in the delivery of poor decisions that have delivered poor outcomes by unskilled and inferior practitioners. To address the entrenched situation, as my team and I travelled across the Northern Territory, we captured this content, determined not to whitewash issues or sanitise those views that eventually contributed to the 23 strategies of the draft agreement and content for the accompanying pathways document. In order to capture the breadth and the depths of diverse views from Aboriginal people across the NT for the agreement and for the pathways document, we made sure that we not only spoke to the voices who were the loudest, or from the people who had the best grasp of English, who were easily accessible, quite often conveniently sitting around in a boardroom for us, or those were members from a peak representative body. No, we did a lot more because we knew we had to. Instead, we listened to and heard from people who spent their lives in the shadows and the background, people who'd been silenced, humiliated and intimidated, where their opinions and views and voices were either not heard or ignored, or they were dismissed. And here's what people told us. We want the chance to determine our own future on our own land and our place in society. The rules of the community should work to protect and strengthen community. But if the rules are being openly disobeyed, then the deterrence effect is neutralised and authority begins to erode. And that elders need to lead meetings and influence decisions to regain cultural authority. Now you may ask the question, why did this process work? It worked because the process we adopted accommodated the realities at play with 30% of the Northern Territory's population, where we developed and we implemented a process that Aboriginal people are entitled to expect and receive, and a process that all of us who work with Aboriginal people should be striving to design, implement and then deliver on. We were incredibly impressed with the response from the many people who, despite their long history and collection of experiences, their want for change was still present. As too was the trust and the belief that this time what was proposed might actually work. Meetings where we met with the sick, the old and the young, the incarcerated and the exceptional role models, and the old stockmen and the would-be, if could-be, shiny cowboys, Aboriginal people who were prepared to offer their time and commitment to be engaged in our process, where the worry lines on their faces were long and deep and their anguish real. Now, I could talk forever on how to do a culturally competent consultation, but I won't. Instead, I invite you to study carefully the narratives from these consults contained within the Pathways document, which has led to the proposed 23 strategies in the draft agreement. So what did the process teach us about the capacity of ADR to address these concerns? Well, that arbitration and mediation seem to work best when parties have roughly equal resources, and there is to some degree an agreed basis for negotiation. Industrial relations is perhaps a good example, and some would argue that the family court is a less successful one. Part of the preference for the ADR process of mediation is a belief that, ideally at least, that parties to any settlement own the result rather than having it imposed upon them. As Chief Justice Grant has said, ADR is not a system like the courts, where the winner takes it all. Clearly, for many Aboriginal people, their interaction with the justice system is very different. We possess vastly different resources and, in many cases, comprehension, with the outcomes remaining often external, mysterious and arbitrary. And this is just as true as it is for victims, as it is for families, as it is for the perpetrators. Consequently, the degree of buy-in, acceptance and compliance remains low, evident in the high levels of recidivism, the high numbers of Aboriginal people breaching bail and other court orders, alongside the poor uptake of parole. So without doubt, this is a powerful argument for rigorously pursuing restorative justice and other forms of alternative dispute resolution processes for Aboriginal people. I'm often asked, what are the particular challenges that need to be recognised and addressed for ADR to be effective in these communities? Well, one area of concern is the level of competence and access to training for mediation, let alone its capacity to be relevant and effective in any Aboriginal setting. I question how many accredited mediators are actually skilled with the level of cultural competency necessary and required to work well with Aboriginal people across the nation. Are these practitioners sufficiently aware of the complex histories of Aboriginal people's relations with the bureaucrats and their apparatus? Because if not, then it is this lack of knowledge that can be just as great an impediment to understanding the desired outcome as is the lack of English amongst many Aboriginal Territorians. As you all know, a mediator's role is to identify each party's needs and interests and to promote mutual understanding and use techniques to broker a mutually acceptable agreement. But from what I've witnessed for many years, perhaps even decades, in reports and documents are words. Words that are presumed to represent or at least illustrate the pinnacle to deliver the best outcome. Words that change as quickly as a second's arm on a clock. Words like cultural competency, cultural safety, culturally appropriate, collaboration, two-way learning, and many, many more. Where I've worked and I've met so many called experts or specialists for decades, and yet the levels of disadvantage or change in the disparity between Aboriginal and non-Aboriginal people remains ever present. But here's what I know. When we asked Aboriginal people across the Northern Territory who was the person in their time who they had worked with, who had got the job done at hand well. And we were told that that person was not necessarily an Aboriginal person. Instead, it was the qualities and skills and experiences of that person that was relevant. Factors that are embedded into that term that I mentioned earlier about cultural courage, and that is the need to respect others and listen deeply while suspending those assumptions and personal preferences that those with power and privilege routinely hold. And for Aboriginal people, the most important deliverable in any process is accountability. And it's not just back to your boss in the city, and it's not just with the words in a document or report, but accountability back to the community, to the very people who you have just met, who voluntarily gave you a few hours of their time so you can get your job done. Accountability includes ensuring that you did your homework and you spoke to the right person or the right people so you got the best outcome, not just for the benefit of some, but for all from that community. To use an analogy, if you're really sick, you just want to go to a doctor or a specialist who knows what they're doing so you get the right diagnosis and you get the best treatment so you get better. It doesn't matter where your doctor was born or what their nationality is or their visa status is or what language they speak. What matters is that you achieved your desired outcome, that the practitioner was held accountable for that outcome, not their intentions or the outputs, but the actual outcome. As we all know, in alternative dispute resolution, the process of mediation has advantages. As often it is affordable and it's efficient and it's effective and it's informal, empowering and confidential. But what does it actually look like in reality for Aboriginal people in remote communities? Well, it isn't affordable when you have to travel hundreds of kilometres by air or road, and at times it may cost you your whole week's pay packet to get to that place that guarantees you privacy in order to mediate. And face-to-face mediation is far more acceptable and preferable because you actually get to witness the other party's body language. Simply watching a response to a question is more likely to empower and satisfy many Aboriginal people's needs regardless of the final outcome. But it isn't a fair or an equitable field if you don't have access to an interpreter to understand the content of the conversations or the ability for you to provide feedback. And as for confidentiality, well, with a small population in small spaces, they're small town talk. And in my experience, very little remains confidential when an official letter is posted with the intention and expectation that it will be you who collects that letter because it's addressed to you, but it is only to be dropped off at a central point where the mail can be collected and opened and read by others. And when phone calls or video link-ups rely on other parties who retain a lingering interest in your confidential conversations. In many community settings, disputes are often labelled evil or poisonous, just like the problems that give rise to them, and that there are no simple or straightforward solutions. Because on both sides, there are people with multiple interlocking and often generation-old relationships that make the determination of a party's interest and advocacy of their position extremely complex, with a myriad of feedback mechanisms and unintended consequences. And it is these and other issues that make alternative dispute resolution both very much needed, but also extremely challenging to deliver in Aboriginal communities. Critically, these challenges mean that to the maximum extent possible, the structures, the processes, decisions and their implementation must be controlled by those who are, or those with the most invested, but also those who have the best background knowledge, but also those with the most to lose. And that is members of the local community, enabled and supported by government, police, judiciary and other services and agencies. Two strategies contained within the draft Northern Territory Aboriginal Justice Agreement relevant to alternative dispute resolutions are the establishment of law and justice groups and the reintroduction of community courts. Available research indicates that there is a direct correlation between local Indigenous leadership and positive community outcomes. Because when Aboriginal Territorians are respected, empowered and supported to make decisions, then responses to community safety, law and order and justice issues are more successful and acceptable within those communities. As noted previously, the 1991 Royal Commission into Aboriginal Deaths in Custody recognised the importance of locally developed community-based justice strategies within a policy of self-determination. Long ago, academic Cunningham concluded that in many cases where Aboriginal community justice initiatives have flourished, there has been successes in reducing levels of arrest and detention, as well as improvements in the maintenance of social harmony. The success of these programs has been acknowledged, deriving from active Aboriginal community involvement in identifying problems and developing solutions. Well, it's no surprise then that community-based law and justice groups are often recommended as a solution. But law and justice groups should be established through a process of community-led planning and design in which the community determines the way its justice group is to be constituted. It's not appropriate to make any assumptions about the appropriate scope and degree of authority needed to deal with offending behaviour of any particular law and justice group. Certainly not prior to the community-based planning process. And nor will every community be ready at this stage to undertake such a process and initiate a law and justice group. Now, members of law and justice groups are generally elders and respected community members, but they should also represent both genders because the effectiveness and legitimacy of law and justice group generally appears to depend upon the degree to which all significant interests within the community are represented. Now, this is an obvious challenge and a hard task to deliver in some places where the history and the interactions between clan groups are complex, not only to understand but also to navigate in comparison to a smaller and discrete and more homogenous community. Equally important is the extent of coordination or collaboration and partnering required between law and justice groups and all the agencies operating within the community. And by this I mean the police, courts and correctional services and all those other services that have the ability to influence the desired outcome, such as child protection, health and education, and all those non-government agencies. But these partnerships require commitment and flexibility and cultural courage from everyone. And while law and justice groups typically operate outside of the legal formal authority, they can exercise de facto legal authority through the partnerships that they create with judicial agencies. And some of the comments from the consults and in the pathway document showcase how law and justice groups can mutually benefit from and contribute powerfully to the authority and prestige of community elders and other important leaders. Community courts for Aboriginal people have been established in most states and territories probably for the last 30 years or so, and they have had mixed success and endured facilitating government support, but they are generally seen as consistent with and supportive of more effective engagement of Aboriginal people in the justice system. Within the draft Aboriginal Justice Agreement, it is expected that community courts will function in tandem with law and justice groups. And given that accused persons would need to opt in for a community court process, it is crucial that both the process and the personnel are seen as fair and not subject to partisan or inappropriate sentiment. Issues of conflict of interest will need to be carefully managed, requiring sufficient choice from possible panels for each hearing. Again, issues of selection, training, accountability and support are paramount to achieve the most powerful benefits of alternative dispute resolution in terms of buy-in and compliance from those before the community courts. A further fundamental problem that ADR shares with the mainstream justice system, especially in the Northern Territory, is a lack of much needed support services, such as alternative accommodation, especially for those seeking bail, mental health services, supervision and meaningful diversion and community service options and so forth. These gaps have been frequently identified in key Northern Territory reports, especially for youth justice. But I'm perplexed as to why we continue to make non-custodial directions when they may be pointless because they are simply unavailable. This question shows why those who support alternative dispute resolution in the hope of just trying to save money by reducing imprisonment might be missing the point. In the short term, ADR may not automatically be cheaper, but it is arguable that ADR processes are profoundly better value for outcomes in terms of human rights and general social order and well-being. Now, I'm not saying that alternative courts and their sentencing systems are the magic fairy dust that's needed or it's the only solution to the problem associated with the disparity of Aboriginal people in the justice system and the subsequent indifference and disengagement of Aboriginal people from these systems. Instead, what I am saying is that along with the strategies and the models of ADR profiled in the Draft Justice Agreement, alternative courts and sentencing regimes have the potential to provide a positive shift in the relationship between the judiciary, Aboriginal offenders, victims and communities. Community capacity, the willingness to engage in criminal justice decision-making processes and local management of community-led and base sentencing options are all prerequisites for the success of community-based justice. And whilst community courts have not proven to lower recidivism rates, literature does highlight their positive impact towards engaging Aboriginal people in a culturally appropriate forum for the administration of sentences and penalties. In fact, most evaluation findings indicate that when compared to the mainstream justice setting, Aboriginal sentencing courts and conferencing have resulted in greater engagement and increased knowledge of and confidence in the justice system, enabling more informed decision making. So to conclude, here's what I know. We need to use alternative dispute resolution in all its forms if we are to improve the levels of disadvantage for Aboriginal people. Where we live or the chance to create safer communities are not factors that should limit our ability to create and sustain safer communities. And those who believe that ADR is a second-rate system of backyard justice that allows the Western legal system to be bypassed, or that it's a race-based get-out-of-jail-free card that favours Aboriginal people, are grossly misinformed. But without accepting the need for local planning and authority, alongside the prerequisite skills for practitioners, then any process of alternative dispute resolution will have little impact. And then by retaining the status quo, it will result in many more Aboriginal people being brought before the justice system, not just as offenders, but also as victims, and ultimately leading to an even higher level of incarceration of Aboriginal people and a greater drift towards widening the current levels of disparity between Aboriginal and non-Aboriginal people. I thank you for listening and I wish you well with the rest of the conference.